May please this honorable tribunal. Were the counsels for the appellants, I'm counsel number 1, Appellants Agro Limited. My co-counsel is appearing for the respective appellants, Mr. Pulkit Sharma, Ms. Anjali Aruna, and Mr. Sami Raman. Your Lordships may appease the jurisdiction of this court under Section 15T of the Securities and Exchange Board of India Act of 1992. We're appealing against the order of the whole-time member of the SEBI. Therefore, we shall be making our submissions on the merits directly and against the contents in the impugned order, Your Lordships, if it so pleases this honorable court. Your Lordships, I will be dealing with issues 1, which is regarding Agro Limited's liability, arguing that in fact we were right in classifying Sundarya as a subsidiary, as an associate company, Your Lordship. And my co-counsel will be arguing with regard to the liabilities of the directors as well as the CFO, Your Lordship. If I may move on to issue number 1, Your Lordship. Your Lordship, the first issue is whether Agro has in fact misrepresented its financial statements while accounting for Sundarya as a subsidiary and is in violation of the SEBI Act and regulations, Your Lordship. Your Lordship, it is our submission that it has indeed not. Your Lordship, our first submission is regarding control. Your Lordship, a perusal of Section 2, subsection 27 of the Companies Act, if the tribunal is with me, as well as Section 2, subsection 87 of the Companies Act, requires 2 conditions to be fulfilled for a holding subsidiary relationship to exist, Your Lordship. Firstly, is that the holding company must have a right to appoint a majority of the directors on the board, Your Lordship. To this end, it's our contention that it indeed does not. Your Lordship, if I may direct the attention of the tribunal to the Articles of Association, Your Lordship, on the Articles of Association on page 22, Your Lordships, of the proposition. Articles of Association, para 66, Your Lordship. The board of directors in the company shall constitute of 5 directors, of which 3 shall be nominated by Agro Limited and 2 directors are to be nominated by Agarwal Group, Your Lordship. A simple perusal and a simple reading of this agreed upon clause, Your Lordship, indicates that the majority of appointments in this case are made by Agro Limited, which is 3 out of the total 5. This is the case, however, before the January 29th extraordinary general body meeting. However, after that, Your Lordship, 2 independent directors were added, which means that now the composition of the board is 3:2:2, Your Lordship. My 3 are appointed by Agro Limited, 2 are appointed by the Agarwal Group, and 2 are independent directors.
I have a question there.
Indeed.
Who is
The chairman of the board is appointed by Agro Limited and is also the CFO of Agro Limited.
and where in the articles can we find that right back to appoint the chairman?
Your Lordships, the rate is given under, I mean, just get a second here. No problem. Your Lordships, the right to appoint the chairman is in fact given in the memorandum of understanding, the same on page 17. Lordships. Para 9, which says that the board of directors will have a chairman from Agro Limited and a managing director from Agarwal.
So could you address that fact as well when you're going through your proposition?
Indeed, Your Lordship. Your Lordship, it is common for the chairman under the secretarial standard to have this right to a secondary casting vote, Your Lordship. Further, merely, and you will see by mere perusal of the section, that such a right to appoint a key managerial position is equally divided, Your Lordship, which means that there is joint control over such appointment when you have Agro Limited appointing the chairman and Agarwal Group appointing the managing director, who is the head. Your Lordship, further, with regard to the current composition of the board is 3:2:2, which means that for any policy to be passed by the board of directors, or any decision to be made, it requires simple majority, which is to say that more than have to agree for the passing of such a resolution, Your Lordship. Your Lordship, it is to be noted that only 3 directors are appointed by Agro. The other 4, which is the 2 appointed by the Agarwal Group and the 2 independent directors, have the right to oppose any such control on any such decisions that are proposed by Agro, which is herein why we're contending that we do not have control over such day-to-day decisions that are being taken in Sundarya in itself. Inter alia, why we're contending that we do not have control under the sections of the Companies Act. Further, Your Office.
I have a basic question here. Are you trying to say this is not a subsidiary, or are you trying to say this is not a controlled? It's not a controlled entity. These are 2 separate things.
Indeed.
I think if I understand the basic is suppression of losses leading into a higher revenue, higher profit overall, leading into stock price, everything else comes together. But the basic point is suppression of losses by desubsidizing.
Indeed.
So are we talking about accounting standard here or talking about?
If you could just repeat that.
So what I was saying is accounting standards dictate what needs to be for it.
Indeed.
I don't think it is necessarily referring to subsidiary or definition of subsidiary under company standards. So are you dealing with the point of whether it's a subsidiary or not?
An investor, he must have the exposure or rights to use its power to direct relevant activities, Your Lordship, as is given in the IND-AS 1. Your Lordship, we contend that because Agro herein does not have power or control over the board of directors, wherein decisions are taken, that is along with the board of directors, first they are not with Agro. Your Lordship, another aspect of the definition in itself also deals with the right of Agro to be able to direct Sundarya to enter into or veto any changes that are made to Sundarya's significant transactions, Your Lordship, under the accounting standards. Your Lordship, without a majority on the board, Your Lordship, Agro is not in a position to enter into any such significant transactions within exclusive control, Your Lordship. It is our contention to this end that it was contractually agreed upon that there would be joint control, Your Lordship. The only thing that was differing until the appointment of the independent directors was the majority on the board, and without that, we lose control. That is our contention. Because any proposition will have to receive a majority of vote at the board meeting, and at the board meeting, Agro no longer has a control, and thus it is no longer a subsidiary.
So who's control?
We contend that Agro, along with Agarwal Group, has joint control over Sundarya.
So in that case, do we need to consolidate or not?
Indeed, not, Your Lordship. Your Lordship, IND-AS 110 only deals with subsidiary companies, Your Lordship. IND-AS 28 deals with associate companies or joint ventures, which does not require such consolidation to be made, Your Lordship. Your Lordship, further to this end, regarding joint control, Your Lordship, it is our submission. If I may direct the tribunal's attention to page 8 of the proposition, para 22. And if the tribunal is with me, Your Lordship, the perusal over item number 13 and 14 is important in this context, Your Lordship, wherein such division of power was equal, wherein Agro would maintain operations and management of the salons, and Agarwal Group had supervisory powers that would ensure that there was a checks and balances system in this case to ensure that such management and operations run smoothly, Your Lordship. Your Lordship, further, if I may direct the tribunal's attention to page 17 of the proposition.
Just a minute, as for point 2 and point 10 at page 8, the management will remain with the Aglo after completion of the saloons.
Indeed.
So Aglo will be in management.
Indeed, Your Lordship. But what is important to contend in this case is that the managing director is appointed by the Agarwal Group, Your Lordship, which ensures that there is joint control over management as well. And this is given in the Articles of Association, Your Lordship, page 22, para 68, Your Lordship. Standing, para 9. Apologies. The board of directors will have a chairman from Agro Limited, and the managing directors will be from Agro. Your Lordship, further.
Sorry, before we move on from this part, I have a question on what you showed us on page 8 of the proposition. So when we're going through how the rights and control is divided into, say, both parties, is it then your case that I am putting words into your mouth, so just answer with patience? Is it your case then that the rights that are listed out for the other one are more protective in nature?
Indeed not, Your Lordship.
What is that?
Your Lordship, they were to be more protected. These are substantive rights that are equally divided between Agro as well as Agro.
And what would be the difference between the Agarwal group being able to appoint an FD versus the Agro group being able to appoint a chair?
Your Lordship, the chairman in this case is a non-executive position, and the managing director is an executive position. Such a distinction has been made, and this is deliberate with an intention to have joint control.
I have an additional question. Please.
Yes.
Within these rights, which are provided on page 8, is there any proposition which provides a hierarchy of rights to determine whether there is a control of one versus another?
Your Lordship, here we contend that there is no hierarchy at all, Your Lordship. We contend that we make decisions, we agree to that, Your Lordship, but control over such decisions, whether such decisions are to be brought into fruition or not, is still with Agarwal Group, Your Lordship, which is why we contend that we have joint control. They're intended either in the Memorandum of Understanding or in the Articles of Association.
Are you saying that Agro decide and Agrawal implements?
Indeed not, Your Lordship. That Aglo as well as Agarwal Group are involved in the decision making when it comes to the processes of the board, Your Lordship. Day-to-day decisions are taken in conjecture with one another. Your Lordship, further with regard to joint control in itself, Your Lordship, on as excerpts from the memorandum of understanding. Your Lordship, if you read every listed item that has been mentioned here, Your Lordship, you would contend that there is some sort of comparison, some sort of balance that has to be brought between both Agarwal Group as well as Agro, Your Lordship. For instance, the first excerpt, Your Lordship. The shareholding pattern of Agro Limited and Agarwal Group in Sundarya Private Limited will be in the ratio of 50:50. Your Lordship, further, 7, Your Lordship, immediately upon the formalization and execution of this understanding, joint account will be opened in the name of Pulkit Sharma representing Agro Limited and Vandana Agarwal representing the Agarwal Group, where each of them initially contribute an equal amount, Your Lordship, of 4 crores, Your Lordship, for initial expenses, construction, and for purchasing an installment of various equipments, Your Lordship. Your Lordship, in 9, board the chairman is appointed by Agro, managing director is appointed by the Agarwal. Your Lordship, even the fee structure, Your Lordship, that is on page 8, item number 11 and item number 12, Your Lordship. A management fee of 0.9% of the turnover and 55% of the gross profits to be earned is given to Agro. However, all of the surplus that is remaining after the payment of such management fees and after reducing the reasonable allowance of working capital is to be transferred to Agarwal Group, Your Lordship. And this is just a few examples of how there is division of control, Your Lordship. Your Lordship, in this case, we also contend.
We have less time, so let's move on from control.
Indeed.
I have a quick question. Mathematical question, Constance. You only have 2 columns in this chart, page 8. There is no third column on independent directors. So you continue to divide your rights between the groups. So how is it pointing to independent directors change this equation which you had before January?
Indeed, Your Lordship. Your Lordship, the Companies Act, Your Lordship, prescribes the code for independent directors, Your Lordship. Ensure that there is some sort of independence and to ensure a checks and balances that is given in the board in itself. And if I may just read for the proposal of the tribunal, Your Lordship, and these are just some examples that I'm reading from the Act in itself, to bring an objective view in the evaluation of the performance of the board and management, Your Lordship, to scrutinize the performance of management in the meeting of the goals and objectives and monitor the reporting of such performance, Your Lordship. Your Lordship, independent directors do not have such direct involvement in the day-to-day activities of the company, which is why we're contending that is so crucial for Agro losing its control. Allegations made on the forensic auditors involved. I may just direct the tribunal's attention to para 12 in the moot proposition, page 5 here. Sure. So para 11. Your Lordship, although we contend that it is important for the board to note here, and this is merely in persuasive value, Your Lordship, that the forensic auditor in alleged of corruption, Your Lordship, which means that there is a reasonable doubt that he is corrupt. There is sufficient red flags in this case to show that the current audit might be tainted, Your Lordship, by corruption, by a way of the forensic auditor in himself, Your Lordship. Your Lordship, it is also important to note the consequences of these charges, Your Lordship. If such charges are convicted, he is bound to lose his license, Your Lordship, which is why we alternatively also contend that the court take the value and integrity of the report that is submitted by such a forensic auditor while keeping into note this allegation in itself here. If there are any other contentions, if there are any questions by the Indeed, Your Lordship. Your Lordship, further, it is also our contention that as per the IND AS 110, because we've proved to you that we're no longer a holding company with control over Sundarya, Your Lordship. It is well within the law under B98 of IND AS, where that when a parent loses control of its subsidiary, it shall derecognize assets and liabilities of the subsidiary at their carrying amounts at the date when the control is lost, Your Lordship. If I may just seek a minute more, Your Lordship, to conclude my submissions. Your Lordship, further, it is also contended that such disclosure, Your Lordship, was made in accordance with the LODR, which is to say that because the meeting in itself took place on a Saturday, Your Lordship, we've ensured that by Monday the market closes. We have disclosed such information, Your Lordship, which is why we're contending that Agro in this case has fulfilled all its obligations, including the fact that we were supposed to appoint independent directors under the Companies Act because we will behave as a public company because we're the subsidiary of a public company, Your Lordship. Along with all of this, we contend that disclosures were also made in accordance with the law. That's about it. If we may move on to issue number 2, if the tribunal does not have any questions, issue 2 and 3. Thank you.
May it please this honorable tribunal, I shall be counsel number 2, appearing for the appellants, Mr. Pulkit Sharma, Ms. Anjali Arora, and Mr. Samir Aman. Your Lordship's issue number 2 is whether Mr. Pulkit Sharma and Ms. Anjali Arora are responsible as charged under the impugned order. And it is our humble submission that Mr. Pulkit Sharma and Anjali Arora are not responsible for the violations of sections 12A, subsections A, B, and C of the SEBI Act 1992, and regulations 3D. 4.1, read along with 4.2, E, F, and K of the SEBI Prevention of Fraudulent and Unfair Trade Practices, PFUTP, hereinafter. I shall be dealing with the same under 3 limbs. Firstly, the classification of Sundarya as an associate company. Secondly, the general price transfer has not been taken into consideration. And thirdly, the SEBI LODR, that is the listing obligation and disclosure requirements that do not apply to NOTCs 2 and 3 respectively. Providing a brief overview before I move into my email number 1, Mr. Pulkit Sharma is the promoter, chairman, and managing director of Agro Limited, and Anjali Arora is the promoter and director of Agro. Here, Mr. Pulkit Sharma and Anjali Arora have wrongly been accused and charged with the violations of prohibitions of the SEBI Act and their corresponding rules and regulations. Just because of an unfoundedly based on their coincidental claims made by them. Mr. Pulkit Sharma, that is note C2, and Ms. Anjali Arora, note C3, prior to the release of the consolidated financial statements made for the year 2021-2022. Here, the appellants maintain that the claim made lacked evidentiary basis and also legal backing. There was no real legal backing, that's to say. Moving on to my first claim, that is a classification of Sundarya as an associate company. Here, it hasn't been proved, and it has already been proved by my co-counsel, that there is no element of misrepresentation, fraud, or manipulation by the directors of Agro. That is note Cs 2 and 3. And therefore, they cannot be held liable for the sections under the SEBI Act. Moving forward, there is no mens rea or intent to commit fraud. And I get to why I use the word intent and mens rea herein. The same shall be true in arguendo. If this tribunal does, however, find that the classification of Sundarya as an associate company amounts to misrepresentation, even in that scenario, both notices 2 and 3 cannot still be held liable because of general lack of mens rea. And this shall be proved with placing reliance on certain judgments, Your Lordships. Moving on. The court in SEBI versus Abhijit Ranjan, and I would like to draw the attention of the tribunal to para 27 of the written submissions. And I would like to cite the rules of the same. An attempt by an insider to encash the benefit of the information is not exactly the same as mens rea. Therefore, the court can always test whether the act of the insider in dealing with these securities was an attempt to take advantage of or encash the benefit of this information in his possession. But moving forward to the other case.
Sorry, I'm going to pause there. I'm sure all of us have the same question. The precedent that you're quoting, is it in relation to the FUTP regulations under which the charge has been levied?
Indeed not, Your Lordship. It is in relation to section 12A of the said Act.
Okay, so then what is the equivalence you're drawing? Because I think what the bench would want to be convinced of is if FUTP and insider trading are fundamentally two different legislations, what from the ratio in Abhijit Rajan can be used insofar as the facts of your case are concerned?
Indeed, so, Your Lordship. In Abhijit Ranjan's case, the Supreme Court also held in line with the SAT, Your Lordships, where it said that the insider's motive is to be looked into account while taking into account whether they've committed insider trading or not. And what the counsel make a humble submission that this court takes into account this argument and take it as a persuasive value and set a precedent in this accordance. Moving forward to the case of Rakesh Agarwal versus the state of SEBI. Further, I would like to draw the bench's attention to paragraph 27 of the written statements here. And I would like to cite, it is true that the regulation does not specifically bring in mens rea as an ingredient of insider trading, but what is not meant that motive need not be ignored. Motive cannot be ignored, and that is the point that is to be highlighted here in Your Lordships. Following these judgments and precedents, the appellants herein humbly submit that concrete intention is reasonably required to be proved, and over here that hasn't been proved to commit fraud, Your Lordships. And also, in the landmark judgment of Hindustan Unilever versus SEBI, it was stated and argued that mere possession of this information does not preclude dealings, Your Lordships. Moving forward, Your Lordships, this flooding that took place in this present case took place when there was wide market appreciation, that there was a very big sector-wide boom that took place for it. And it cannot be reasonably thought that there was monetary gain just because of this. All other companies as well did well in this particular sector that Agro worked in. And that can be found in clarifications 10, Your Lordships. Moving further, the standard of proof for violation
Yes, like council, but everyone was making losses, right?
Agro was not making losses.
Was not making losses for preceding years?
Indeed not. The standard of proof for violation under section 12A needs to be met. Here, I see a simple reason that I do agree that this is not a criminal case. However, this is a case of a civil nature. However, over here, the preponderance of possibility has to be of a higher level. And the same was also held in Belief Bensie's case versus SEBI. And it was said that higher must be the preponderance of probabilities. That is why we need a higher level than compared to a civil case, even though it is less than that of a criminal charge. And others versus SEBI, Your Lordships. Moving on to name number 2 of my argument. That is the general price. Price has not been taken into consideration. As I've already mentioned, Agro was working in an industry where there was a sector-wide boom. And for your perusal, the range in which the boom took place was 46% to around 103%. So it cannot be stated that there was an abnormal profit that Agro made during this sector-wide boom, where other companies in this sector also made a certain amount of profits, where a company also made around 103% of profits in the same sector.
I have a question.
Indeed, so much.
If you compare with the industry-wide peers, that jump around 103% is in a period of 11 months, around 18 months. While in your case, it is within 11 months, around 150%. if you were to look at para 31, where the trades have been mentioned in the proposition, a company's director is selling and buying within 6 months. So should you at least not be happy that you've not been charged for contra trade under the insider trading regulation?
Indeed not, Your Lordship, because this was public information in itself, Your Lordship. The financial statements of the company were already made public, and the information was in public domain, Your Lordship, and therefore you cannot charge it under insider trading, Your Lordship.
For a charge of contra trade, do you require your information to be public?
I'm sorry, Your Lordship, please repeat.
For the charge of a contra information to be public.
Indeed, so, Your Lordship. Proceeding. Here, the SEBI listing obligation disclosure requirements do not apply to notices 2 and 3. That is, notice 2 and 3 herein have been accused of regulations 4.1, 33.1a, 33.1c, 33b, and 40a respectively. From a bare reading of these said provisions, it is evident that these penalties are applicable under the regulations, and the SEBI Act of the above mentioned provisions are only applicable to listed entities. And over here, these are mere individuals, Your Lordships, therefore cannot apply to them. Here, the violations under section 33 2A of the LODR is with regard to the approval of authentication of financial results, and the approval and authentication is to be done by either the CFO or the CEO of the company, and this was reasonably held in removing the liability of the other directors in the case of Neha Naresh Pillai versus SEBI, Your Lordships. If the bench is satisfied, may the council proceed to issue number 3.
Isn't your contention that under these regulations, only a company can be proceeded against and not the directors?
Indeed not, Your Lordship. But here I'm saying only a listed entity under section 12A can be made liable, Your Lordship.
So listed entity is a company, so company is a listed entity, individuals are not listed. And therefore, no proceedings can be initiated by SEBI against individual directors.
Under section 12A and subsection B. Yes, Your Lordship.
Madam Counsel, sorry, but I believe that the charges which have been framed against your clients are given in section 27 of SEBI Act.
Indeed, so, Your Lordship. Since you bring into question section 27 of the SEBI Act, section 27 subclause 1 provides or reads clearly, and this is an argument to my official statements is already being submitted in this court, Your Lordship. And I would like to cite for the perusal of the bench. That in any case, there is an allegation of fraud that has been proven against the company. The people responsible for the conduct of business shall escape liability if they can establish that they were not informed of the fraud and it was alleged and it was done without their knowledge or their consent. Here, Mr. Samir Rahman, who was the CFO, had no knowledge of the fraud and he had no intention to commit such fraud on the public, Your Lordships.
Isn't he the signatory to the financials?
Indeed, so, Your Lordship.
Signed without the knowledge.
Indeed not, Your Lordship. He believes, because of the legal opinion, that the classification of Saundarya as an associate company is valid in Your Lordships.
Madam Counsel, how does that prove the lack of knowledge?
The lack of knowledge to commit fraud, Your Lordships. He had no intention therein. It is also important to note here that the appointment of the CFO is in isolation to that of the chairman of Saundarya, and is in isolation, does not automatically grant Advocate the power of control over Saundarya, Your Lordships. Here, Samir Rahman was not on his financial statements, Your Lordships, and it is submitted because these publications that were done, he was either involved in causing to publish or these publications directly, Your Lordships. Because under Proviso 32(2)A of the listing obligations and disclosure requirements, it is given that the CEO or the CFO are required to certify, merely certify, Your Lordships. And this should still be done in account of the board. And in any case, if this tribunal does find Mr. Samir Rahman responsible, the board of directors also has to be held liable. Liability has to be shared, Your Lordships. Moreover, under the LODR, it is an essential requirement of the audit committee to scrutinize and review these financial statements as per regulation 24 subsection 2 of the LODR. And here, because the audit committee has to ascertain whether the balance sheets exhibit a true and fair nature of the company's accounts. And not only that, to the CFO, your lordships, and based on what information he was submitted is what he just complied with his duty as a CFO, your lordships. Now,
When the financial statements go to the audit committee, do the CFO involved in that? Because someone has to put out the financial statements. Financial statement to CFO, we will be responsible.
Here in your lordships, Mr. Pulkit Sharma, who's also the CMD, has also signed and forwarded the financial statements, and that fact is already made available as per para 34 of the moot proposition, your lordships.
So you're saying that for Pulkit Sharma and Anjali Arora, in addition to the charges which are already there, the charges insofar as the financials should also be attributed?
Indeed, not your lordships. It is an argument that Mrs. Nirmal should not be held responsible for in any case. If someone is to be held responsible, then liability is to be hoisted for. We talk about advertisement because advertisement includes notices, brochures, advertisement under section 2(1)(b) of the ICDR. That is the issue of capital and disclosure requirements. Here, advertisement includes notices, brochures, pamphlets, show cards, catalog, hoardings, and offer documents and in any print media. On a bare reading of this definition, financial statements can reasonably include the definition of advertisement. Moreover, it is an inclusive definition, as the definition in itself begins with the word includes, your lordships. It is very well understood that the unaudited financial statements are required to be published by every listed company on a quarterly basis, and they form the very basis for investing by the public in that company, your lordships. Here it is a settled position in law that imposing a punishment under the PAQTP regulations on the ground of commission of fraud requires a clear and an unambiguous evidence and a high degree of probability, which has not been proven in this case, your lordships. And therefore, no evidence as against Mr. Samir Ahmad for having proved the intention to defraud the public has been expressed. And no conclusive proof that he wanted to publish such false information that was not true to the best of his knowledge. He believed that the information he was getting published was true to the best of his knowledge, and that is why permitted the declassification of Saurarya as from a subsidiary company and an associate company, your lordships. And there was no manipulation of these price securities in my third limb of argument, your lordships. Now it can clearly be interpreted that the act will be violative of section 4.2 when a person is dealing in these securities, your lordships. Manipulation herein is defined as altering or presenting to mislead, your lordships. In most of these manipulation cases, it is very all. Number one, and the sequence of events. Herein, there was a staggered offloading of these shares, and the same can be seen in para 31 of the proposition, your lordships, where Mr. Pulkit has definitely offloaded his shares, but there can't be a substantial chain that's established because there's a staggered offloading and the chain breaks thereafter, your lordships. Mr. Samir Ahmad simply acted in the capacity of him being the CFO of Agro and did so on the basis of what information was merely given to him, and therefore cannot be reasonably held that there was any manipulation or deceptive devices that was used against him. Here, it is also contended that the punishment that is imposed is not proposed. Under 2 points, your lordships. Firstly, he was a non-executive director of Sundar because he was a nominee from Agro's board. And although he did have the knowledge, it was attributable to only the board processes. He did not consent, he did not connive, or fail to exercise his due diligence in respect of filing these annual financial statements, your lordships. And a non-executive director does not become liable for the which is on para 55 of the written submissions, Your Lordships. Consent here is more explicit for an illegal agreement to be committed. However, connivance here is where an officer is usually aware of what is happening, but merely its agreement is tacit, not actively encouraging what happens, but letting it continue without saying anything. It is submitted here in the present case that there was no agreement, explicit or tacit, between Mr. Samir Rahman and the other directors of Agro while filing these annual financial statements, Your Lordships. And that's a very important case here, which is PP Loki versus MG Your Lordships. It was stated that in order to sustain an action under 628 of the under section 628 that deals with the penalty for making a false financial statement, it had to be proved that there was a dishonest intention. As mentioned, is a very essential ingredient of a criminal proceeding, and this needs to be proved before proving a guilty mind, Your Lordship. If Your Lordships have any questions at this point.
No.
May the Council authority cited, it is most humbly prayed and implored before the Securities Appellate Tribunal to dismiss notices 1, 2, 3, and 4 passed by the whole-time member of SEBI. Secondly, to declare the classification of Soundharya as an associate company as valid, to declare the consolidated financial statements of the year 2021-2022 of Agri that are in compliance with the accounting standards that apply to it, and declare notices 2 and 3 that they have not made any wrongful claims hereafter, and pass any other order that this tribunal may be written in the interest of justice, equity, and good conscience. It was indeed an honor to argue this bench. Thank you. Greetings to the bench. This is the first counsel appearing on behalf of the respondents. The respondent would argue on 5 grounds. Firstly, Soundharya is a subsidiary of Agro. Secondly, due diligence was not exercised by the appellants. Thirdly, the contraventions have been established against the appellants. Fourthly, the non-executive director should be held liable for financial misstatements. And lastly, the SEBI order does not warrant intervention by the staff. Your Honours, the first counsel would argue on the first 2 grounds, while the remaining 3 grounds would be argued by the court. Your Honour, before delving into the argument that Soundharya is a subsidiary of Agro, first we need to determine that which definition of control needs to be taken into account for preparing the financial statements. Your Honour, control is the prerequisite for determining the holding subsidiary relationship. Under section 2 clause 27 and 2 clause 87 of the Companies Act, control and subsidiary has been defined respectively. It lays down 2 conditions: majority in the voting rights or control over the composition of board of directors. It is different from what is given in the Indus content guidelines. Indian accounting standards 110 lays down 3 conditions to establish control.
Does SEBI have a definition of control?
No, Your Honour.
Any of its regulations?
Yeah. Your Honour, in the SAST regulations, SEBI has the definition of control. So, in the Indian accounting standards, lays down 3 guidelines. The question is, which definition is to be considered for preparing the financial statements? Section 129 of the Companies Act states that the financial statement should be prepared according to the accounting standards. Also, the LODR regulation 48 states the same, that the regulation should, the financial statement should be prepared according to the accounting standards. Hence, Your Honour, it is humbly submitted, the financial statement should be prepared according to the accounting standards only. Your Honour, the appellants in the first issue have based their reliance on the definition of the Companies Act 2013. However, in the present case, that definition do not hold any value as it pertains to the preparation of financial statements within which, as per section 129, should comply with the accounting standards. Your Honour, subsidiary of Agro, as all the 3 conditions are established in the present case. Agro has power over Soundharya even after the change in the composition of board of directors. Let me refer the bench to page 1, para 4 of the memorial, second line.
Page 1,
Para 4 of the memorial.
if the majority members of the governing body that directs the relevant activities are appointed by a vote of the holder of the majority voting rights, then that holder has power over the industry. Your Honor, the governing body in the present case is the board of directors as it controls the day-to-day functioning of the company. On board of directors, 3 members are nominated by AGLO, 2 by Agarwal Group, and further 2 independent directors are appointed by an ordinary resolution through general body. Your Honor, AGLO through its 50% shareholding and second or casting vote of the chairman can unilaterally appoint or remove the 2 independent directors. Thus, AGLO has power to appoint or remove total 5 directors out of 7, which shows that AGLO has power over Sundarya. Secondly, Your Honor, AGLO is exercising power through contractual arrangements as well. If I may refer the bench to page 2, para 11 of the memorial. If 2 or more investors through contractual arrangements have existing rights that give them the unilateral ability to direct different relevant activities, the investor that has the current ability to direct the activities that most significantly affect the returns of investee has power over the investee. Your Honor, the MOU divides the rights between Agarwal and AGLO. AGLO has operation and management.
Is MOU legally binding document?
Your Honor, it is not a legally binding document, but it divides the rights. And also, if we read only the Articles of Association, then also it can be established that AGLO has power over Sundarya.
I remember Council 1 on the other side, she said that some powers are only coming out of the MOU and they're not in the articles, especially the one on the second Council. So, which document are you relying to say that they are?
Your Honor, it is undisputed that chairman has the second or casting vote. At 150 clause 2 mentions the independent directors and 152 clause 2 said that directors are appointed by the general body meeting. Then again 169 mentions the removal of directors by ordinary resolution. So through the general body meeting, ordinary resolution takes place, and in the general body meeting there are members of the shareholders. AGLO and Agarwal Group both has 50% shareholding, and the chairman has second or casting vote. So through the ordinary resolution, AGLO is exercising power in the general body meeting in appointing or removing the directors.
So this casting vote is for board voting or is it for shareholders vote?
Your Honor, para 39 of the Articles of Association, page 21 states that in the case of an equality of votes, whether on a show of hands or on a poll of the chairman of the meeting at which the show of hands takes place or at which a poll is demanded, shall be entitled to a second or casting vote, and it is mentioned under the general meeting. It is nowhere mentioned that it is for the general, that it is for the extraordinary general meeting. Hence, Your Honor, it is humbly submitted that the MOU divides the right between AGLO and the Agarwal Group. AGLO has operation and management. Hence, AGLO has a discretion over the activity which more significantly affect the returns of Sundarya. Your Honor, it is humbly submitted that AGLO has power over Sundarya. Your Honor, the second condition, AGLO is exposed to the variable returns from Sundarya. If I may refer the bench to page 3, para 14 of the memorial, an investor has rights to variable returns from its involvement with the investee when the investor's returns from its involvement have the potential to vary as a result of the investee's performance. And it is mentioned under para 15 of Indian Accounting Standards 110. Your Honor, it is undisputed that AGLO has the right to 0.9% of the turnover and 5% of the gross operating profit as the management fees. Thus, AGLO is exposed to the variable returns as the management fee will vary depending on the turnover and the gross operating profit, which in turn is dependent on Sundarya's performance. Hence, Your Honor, it is humbly that AGLO is exposed to the variable returns from Sundarya. Your Honor, the last condition, AGLO has the ability.
Every franchisee arrangement will be like that. So Domino's globally controls whatever Domino's India, probably that's not how it has been shown in Domino's India as far as Domino's India is listed. It's the companies for Jubilant Food, for example. So are we saying Domino's globally, which gets certain percentage of the top line, which is the revenue, or percentage of of the PAT, the profit, makes it in control over Domino's India?
Your Honor, Indian Accounting Standards 110 lays down all the 3 conditions, and all the 3 conditions needs to be established. In this, AGLO is exposed to the variable returns. We have to establish this. And other than this, we have to establish that all the other conditions, the first and the third conditions are established to have control. Only having the exposure to variable return does not suffice, that it is having control. Your Honor, the last condition, AGLO has the ability to direct the activity.
Finish it.
To direct the activities to affect its return. If I may refer the bench to page 3, para 16 of the memorial, to have control, the investor should have the ability to affect its returns. That is, it should be a principal in taking the management decisions and not an agent of another entity. Your Honor, the council would submit that AGLO in its capacity in operating and managing the salons is acting as a principal and not as an agent. Because an agent can always be removed by the principal. So if an entity cannot be removed from its right, it is acting as the principal and not as the agent. Your Honor, AGLO has operation management by virtue of memorandum of understanding, so it cannot be removed from this right. Hence, AGLO has the ability to direct the activities to affect its returns. Thus, Your Honor, it is conclusively submitted that AGLO has control over Sundarya as all the three conditions which are laid down in the Indian Accounting Standards World 10 are established in the present case.
So I think the crux of their argument really is you're trying to bucket this under fraud, misrepresentation, manipulation. Both the charges. Is there or is there not kind of an argument on both sides? They've gone to an external counsel. With all of those facts, even if there's a little bit of chance that another interpretation of AS 110 is possible, how can you charge them under fraud? Is I think the crux of their argument.
Your Honor, my co-counsel will be dealing with this particular argument.
I'm on charge one only. So charge one, you will be dealing with that. In terms of that, if it's misrepresentation, the standard is high. If there's an arguable case on the other side, that whole thing has to fall because you're charging somebody who's under quasi-criminal law.
Your Honor, the whole contention by the appellants is that there is change in the composition and thus they have lost control. The first counsel is establishing that AGLO has control over Sundarya, and then the co-counsel would be establishing that contraventions have been established. If Your Honor does not have query, may the co-counsel proceed with the arguments. May the counsel proceed with the next. Your Honor, due diligence was not exercised by the appellants in the present. The PFUTP NODR Regulation 4, Clause 2, Clause F, Clause 3, Clause 7 mentions that the Board of Directors is bound by law to exercise objective, independent judgment on corporate affairs. Your Honor, by bare reading of the Memorandum of Understanding and Articles of Association, we can see that AGLO has power over Sundarya even after the change in the composition. That either they did not read the MOU or AOA, or they blindly relied on the third party opinion and did not exercise their own independent judgment. Hence, Your Honor, the counsel humbly submits that the appellants did not exercise their own independent judgment. Further, additionally, Your Honor, SEBI in the order of Bombay Dyeing and Manufacturing Company Limited stated.
What's independent judgment standard you have? So what they've done is they're working to fix any counsel. They can agree with the CFO or internal management. So what you would do is you would actually go and seek counsel or seek advice from experts. That's what they've done.
Your Honor, the is very well aware of the fact that they have the authority to appoint or remove the directors, which shows that they have control over Sundarya. So if they have carefully read the MOU and AOA, they would have known that they have control.
So, sorry, what is in your case? Is your case that this is a fraud that they have perpetrated because both cannot coexist? Today, the lack of diligence is basically negligence on your part. You have applied your mind to the facts and relied wholly on what a third party has told. That cannot coexist with the charge of fraud. They are mutually exclusive. So, what is your case?
So, Your Honor, for this, I would like to point out this case by the SEBI in the matter of Bombay Dyeing and Manufacturing Company. They stated that an action would not be legitimized merely because it was supported by an external, independent, legal professional opinion. Hence, Your Honor, due diligence is a defense. The due diligence is a defense that they use that we are rebutting. If Your Honor does not have query, my co-counsel will further deal with the three arguments.
consistently function or utilize. Greetings. May it please the bench, this is the second counsel appearing on behalf of the respondent, and the counsel would argue on the remaining three issues. Firstly, that the contraventions of fraud and unfair market practices have been established against the appellants. Secondly, that the non-executive director or the chief financial officer cannot be absolved of their liability for making out financial statements. And thirdly, that the order passed by SEBI does not warrant any intervention by SAT. Your Honors, coming to my first argument, that the contraventions have been established against the appellants, it is necessary to understand which contraventions have been alleged against the appellants in the first place. The respondent has alleged that the appellants have violated Regulation 3 and 4 of PFUTP and Section 12A of the SEBI Act, which relate to fraudulent trade practices. And secondly, that they have violated the LOTR regulations, which stipulate that financial statements should have been prepared in accordance with the Indian accounting standards. The counsel would go on to proceed on how fraud has been established against the appellants in the present case. Your Honors, the appellants argued that mens rea is an essential element for sustaining a charge of fraud under PFUTP regulations. And the entire argument that fraud has not been established against them was based on the requirement of a mens rea or guilty intention or motive. However, all these three elements are not required to be established for sustaining a charge of fraud under PFUTP regulations. If the counsel may refer Your Honors to page number 5 of the memorial, page number 5, Your Honors, paragraph number 21. The Honorable Supreme Court, in the case of Shriram Mutual Fund, has held that, and I am quoting, a breach of a civil obligation which attracts penalty under the provisions of SEBI Act and the regulations thereunder would immediately attract the levy of penalty irrespective of whether the contravention was made with guilty intention or not. Unless the language of the statute indicates the need to establish the presence of mens rea, it is wholly unnecessary to ascertain whether such a violation was intentional or not. Further, in a very recent case of the Supreme Court, in the case of Kanhaiya Lal Baldev Bhai Patel versus SEBI, the Supreme Court on paragraph number 23 of the memorial, Your Honors, page number 5, has held that the insertion of the word whether in a deceitful manner or not in the definition of fraud in PFUTP regulations 2003, in contradistinction to the definition of fraud in PFUTP regulations 1995, clearly reflects the legislative intent to exclude the requirement of mens rea. Your Honors, it is humbly submitted that the case relied upon by the appellants were cases firstly of insider trading, which are not as applicable in the present case as the case of Kanhaiya Lal Baldev Bhai Patel, which was very similar in facts and circumstances. Secondly, the cases relied upon by the appellants were regarding synchronized trades, which is again not a question to be determined in the present case.
Mr. Counsel, I have a question.
Indeed.
The two judgments which you have relied upon the Supreme Court are in the context of Chapter 60 of SEBI Act, which talks about penalty. You have already passed an order and penalized them.
Indeed.
However, you have passed also directions under 11 and 11.
Your Honors, justifying the other orders, other than the penalty, justifying the other orders, may the counsel do it towards the end after establishing the contraventions? If Your Honors allow that. Secondly, Your Honors, established. If I may refer you to paragraph number 29 of the memorial, Your Honors, page number 6. The Honorable Supreme Court in the case of Kanhaiya Lal Baldev Bhai Patel has held that the definition of fraud is an inclusive definition and therefore is broad and expansive. A mere inference rather than proof that the person induced would not have acted in the manner that she did, but for the inducement is sufficient. No element of dishonesty or bad faith in the making of the inducement would be required. Thus, the only element that needs to be proved by the respondent to sustain the allegations of fraudulent activities is that there was inducement caused to the investors by the actions of the appellants. Your Honors, it is undisputed in the present case that Sundaria was a loss-making entity. That declassifying it as a subsidiary led to a remeasurement of 17.77 crore rupees in the annual financial statements. It is very clear that when the market would see a sudden jump of profits of 18 crore rupees, the investors would be induced to purchase the shares in the market, which is further substantiated by the finding that the shares of Agro went up to 150% hike in 11 months as compared to 100% or 70% of the competitors in a period of 18 months, as rightly pointed out by Europe. Further, the Honorable SAT has held that misleading information which may induce the public to sell or purchase securities would come within the ambit of unfair trade practice, thereby attracting provisions of the PFUTP. Thus, Your Honours, as the Council has established that there was inducement because the investors had purchased the share relying on the financial statement, and the inducement occurred due to the acts of the appellants, as they were the ones who published the financial statements and they were the ones who intimated the public through the stock exchanges. The allegations of PFUTP violations have been established against them. The Honorable Supreme Court in the case of Kishore R. Ajmera has held that where direct evidence is not available, circumstantial evidence is sufficient. And the Supreme Court in the case of Kanhaiya Lal Baldev Bhai Patel has held that the charge to prove a degree, the degree of proof for sustaining a charge of fraud is that of a preponderance of probabilities, in the opinion of Honorable Ranjan Gogoi. Your Honor, it is humbly submitted that on a preponderance of probability, considering the circumstantial evidence of 17.77 crore rupees, considering that subsequently the share prices went high of 160 to the extent of 160%, it is humbly submitted that the investors were induced to purchase the shares and hence the charges of fraud have been established and the violation of PFUTP 3 and 4 regulations and violation of section 12A of SEBI Act has been sustained. If Your Honours have any queries. Indeed.
So in terms of the timeline, why don't you walk us through the timeline again? When was the disclosure made by the company that the Soundarya is no longer a subsidiary?
Your Honours, January 31st, 2022.
Okay, and when were the first of the impugned trades? When did they happen? Starting date. First of the trades.
Your Honours, on February 4th.
Okay, so it's a fact that those trades happened after the disclosure was made. That Soundarya is not a subsidiary. So if that information was in the public domain, what is the case you're making under FUTP?
Your Honours, the case that is being made under FUTP is not that there was concealment of information on part of the appellants. Instead, it is humbly submitted that the intimation to the public through the stock exchange of a wrong information was the fraudulent activity in the present case. Thus, the appellants published wrong financial statements which showed 18 crore rupees additional in profits, and then this subsequently led to a rise in the price of the shares. Within 4 days, Your Honours, it can be seen that the price jumped from 40 rupees per share to 50 rupees per share. So this sudden jump shows that the jump is attributable to this information which was passed on to the public. It is not the case of the respondent that there was concealment from the public. It is the case that the appellants had published information which was wrong and which led the investors to be induced into purchasing their shares. May the council proceed with the next argument. Your Honours, it is.
I have a question.
Indeed.
If that's the case, that in January the publication of the information happened on the stock exchange, and why you as the respondent have taken the trades which are in December 2022 as the wrong feature?
Your Honours, it is humbly submitted that we not take only the, if you may refer to the table on page number 11, paragraph number 31. It's not only that we took the undue gain 22. The assessment of undue gains was made by deducting the price of shares as on 31st January 2022, when the information was not disclosed and the market was running properly, from the date the information was offloaded. Thus, it is not the case that we reduce the shares, the price of shares as on 12 December from the price of shares as on 31st.
I'm not asking for the computation. I'm asking why at all the trades December, which are around 12 months later to the announcement of information, is being considered to be the wrongful gain. Would you also take some trades which are undertaken today? But where does this end? The computation of wrongful gain.
Your Honours, it is humbly submitted that it's not necessary that immediately the day after or the week after the publication of information, the entire price rise will happen. The rise in price of the shares happens in a cyclical manner. based on the misinformation, the first investors would have purchased the shares, which would have again led to a rise in the share price, which would have further that is started by the publication of financial misstatements. There's no cutoff date to be established in the present case that the investors up to this date were purchasing the shares based on the financial misstatements, and after that it was a normal flow of the market. May the council proceed, Your Honors.
So that would logically imply that the cutoff date will be till the consolidation actually occurs again after this. So it's probably a couple of years.
Indeed, Your Honors. Your Honors, it is humbly submitted that the LODR regulations have been violated because the LODR regulations required the appellants to prepare the financial statements in accordance with the Indian accounting standards. My co-counsel has sufficiently established that by a bare reading of 3 or 4 clauses of the Memorandum of Understanding and mainly Articles of Association, it is clear that may the council speak without the mic. Am I audible?
Yes.
Your Honors, thus it is humbly submitted that the LODR regulations require that the financial statements should have been prepared in accordance with the Indian accounting standards. Mere fact that these were not prepared so is sufficient to establish the violations of LODR regulations, and it is no defense on part of the appellants that they acted on a bona fide misinterpretation of law. Because, Your Honors, it is a settled position of law that wrong interpretation of law or mistake of law is no excuse, no mistake of fact is an excuse. If I may refer you to page number 8 of the memorial, Your Honors. The Supreme Court judgment of Dinesh Chandra has held that, paragraph number 40, Your Honors.
Paragraph number
40. The consequence of accepting the mistaken interpretation as a valid defense would be that whenever an accused thought that the law was thus and so, he is to be treated as though the law was thus and so. The rules of law enforce objective meanings to be ascertained by the courts. Thus, and I emphasize here, the court holds that it is no defense that the accused acted on a mistaken interpretation of the statute, which he honestly believed to be true. Thus, in arguendo, there was no malified intention, there was no mens rea on part of the appellants. These are not factors to be considered because this is a case of civil proceeding, and for the imposition of penalty, mens rea or guilty intention or the acting in bad faith is not required, and the mere fact that the contravention was established is sufficient. May the council proceed with the argument on non-executive directors. Your Honors, it is also submitted that the non-executive director should also be held liable for the financial statement. Because LODR Regulation 4.2F Clause 1, Subclause 1 states the key functions of the Board of Directors and ensuring the integrity of the financial accounts of the company and that they comply with the acts and comply with the relevant accounting standards is one of the key functions of the Board of Directors according to the LODR regulations. Your Honor, the non-executive director, though he is not an executive member, is present on the Board of Directors and thus he cannot be absolved of his liability. If I may refer you to paragraph number 46 of the memorial, Your Honor, page number 9. The Delhi High Court in the case of S.S. Thakur has held as follows. If SEBI is able to prove that the offence by the company was committed with the consent or connivance of any of the appellants, they shall be guilty in terms of subsection 2 of section 27, even if they were not persons in charge of and responsible to the company for the day-to-day functioning of its business. In the present case, it is not the case of the appellants that the non-executive director or the chief financial officer were not aware of the financial statements or that they were not privy to them. They had participated in the board meetings, they had signed the financial statements, and hence they had given the consent to preparation of these financial statements, and hence they should be held liable. Further, Your Honors, just to point on a side note, the appellants had argued the chief financial officer being a non-executive director of Sundarya should not be held liable. It is humbly submitted that the chief financial officer, Mr. Samir Awal, is being implicated in the present case as the chief financial officer of Aglo and not in his capacity as the non-executive director of Sundarya, and hence that argument does not stand. Lastly, Your Honors, the council would argue that the order passed by SEBI does not warrant any intervention by SAT because all the grounds on which the appellants had relied stand rebutted. First, Your Honors, it was said that Agro does not have the right to appoint majority on the board of directors, which was clearly proved to be wrong because Agro has power to directly nominate members on the board of directors, and further, it has the ability to unilaterally 50% of the shareholding and the chairman, second or casting vote, and thus it has the power to unilaterally appoint the 2 independent directors. Thus, it has the right to appoint 5 out of 7 members on the board of directors. Secondly, it was interestingly argued by the apparent that there is joint control in the present case. Your Honour, the definition of joint control has been given in Indian Accounting Standards 28. It says that joint control is a condition where the 2 entities have to unanimously act together and every action requires the unanimous consent of the parties. In the present case, this is not the case. The rights have been split between the parties. For the appointment of auditors, for example, it is not the case that it is Agro and Agarwal Group should unanimously agree to appoint the auditors. Agarwal Group can unilaterally do that. For operations and management, Agro can unilaterally do that, and hence there is no question of a joint control existing. Secondly, for establishing that there was joint control, they relied on the memorandum of understanding, saying that the managing director is appointed by Agarwal Group and supervision over the management rests with Agarwal Group. Your Honour, it is admitted that the memorandum of understanding has not changed in the present case. The memorandum of understanding has been like this since the year 2007. However, until 2022, based on this memorandum of understanding only, the appellants had continued to consolidate Sundaria as a subsidiary. Now they cannot come and say that based on the memorandum of understanding, we do not have control, or that there was a situation of joint control which was stipulated, because for the last 15 years, they had consolidated Sundaria as a subsidiary when the memorandum of understanding and the clauses were the same as they exist today. Secondly, Your Honour, it is simply submitted that the allegations on auditors they point out and that there is an FIR somewhere on the forensic auditor does not hold any water, because if I may refer you to page number 16 of the argument, Your Honours, paragraph number 74. In exactly similar facts and circumstances, SEBI has held that the alleged involvement of the forensic auditor in any corruption case subsequent to submission of the FIR in this matter would not, in the absence of any legal mandate or compulsion of law, be treated as a disqualification to perform the job of a forensic auditor. More so, when there is no absolute finding to the effect of their involvement in the corruption case by any court of competent jurisdiction till date. In the absence of any serious anomaly pointed out in the FIR, it cannot be questioned merely for the reason that the authors of FIR have been named in some FIR pertaining to some other related matter.
Your own SEBI orders, are they binding on appellate tribunal or even have the persuasivity?
Your Honours, they are not binding. However, in the case of Supreme Court judgment in Prakash Gupta, they would have a persuasive value. If I may refer you to page number 16 again, page number 16 on Your Honours. Last paragraph, paragraph number 77. The Supreme Court in Prakash Gupta has held that SAT must obtain the views of SEBI before taking decision. These views, unless manifestly arbitrary or modified, must be accorded a high degree of deference. The court must be wary of substituting its own wisdom on the gravity of the offence or the impact on the markets while discarding the expert opinion. As established earlier, that there is no requirement of mens rea, and that SAT is bound by the Supreme Court, and Your Honours, it can't set a precedent as argued by the appellants. The same regard, Kanhaiya Lal Baldev Bhai Patel and Shriram Mutual Funds, it cannot be argued that this tribunal should set a precedent while differing from the view taken by the Supreme Court. Secondly, Your Honours, it was argued that the price rise in the sector is not attributable to the financial statements. However, giving a cursory view on the price of the shares in the market shows that within 4 days, the prices have risen from 40 rupees to 53 rupees, which cannot be said to be merely an external play of market forces, and it is attributable to the financial statements. The degree of proof as argued upon by them is that there should be some high degree of proof rather than mere preponderance of probabilities, which again goes in clear violation of the Supreme Court guidelines given in Kanhaiya Lal Baldev Bhai Patel, which held that even KPTP regulations fraud can be established based on a preponderance of probabilities. Lastly, saying that the exercise due diligence would not act as a defense because they were supposed to exercise their independent objective judgment and merely rely blindly upon the opinion of a law firm and a company secretary cannot absolve them of the liability. Your Honor, the appellate court was the chief financial officer of Agro and he was the chairman of Sundarya. How can it be expected that these 5 pages of memorandum of understanding and articles of association, which give him clear powers, were not known to him, and he had to consult a law firm and a practicing company secretary, and he had to act upon their legal advice rather than exercising his objective independent judgment. With this, the council would conclude. May the council recite the prayer.
Mr. Council, I have just one question. Have you done as a respondent your due diligence in terms of the correlation between your directions and the prevention chart? Because you have also banned a person from trading in the securities market, a person who's not alleged to have committed any trade violation. Samir Nigam, CFO.
Yeah.
Person has not been charged for any kind of a trade. But he's been debarred from trading in the securities.
Your Honor, Section 27 of the SEBI Act imposes vicarious liability upon the officers who were in
Does that include a CFO?
officer in Your Honor, the CFO is a member of the, Your Honor, just an extension of 1 minute. The CFO is a member of, is a key managerial personnel as per the definition of the Companies Act. Played an active position present case because he was the one who conducted the detailed research. He was the one who intimated to the chairman and managing director that Sundarya should be declassified. He has played an active position. He is also liable for the consequences. Then the council proceeds with the hearing.
Just a quick, so I think we've repeated ourselves 2-3 times on this point. I think the fundamental issue is you saying the other side was wrong in his decision versus saying that the other side was fraudulent. You may have convinced us about the first, but it doesn't go to the level of convincing us that fraud is occurred. You know, like you said, they should not have relied on external opinion. Well, if you go to a heart expert for whether your arteries are choked, do you rely on your own wisdom or do you rely on the expert?
Indeed. The facts and circumstances.
Our entire argument lies down on the fact that we do not have control, Your Lordship. The point at which we're able to prove to you that we do not, in fact, have exclusive control, the entire case of the respondent hearing will break down in much. Because at this point, it is important to note that when the MOU was agreed upon, as well as the articles of association were agreed upon, control was never meant to be static, Your Lordship. Allowing for the appointment of the independent directors meant that it was contractually agreed upon that the entire point of control would be dynamic in nature, Your Lordship. And the only thing that stopped Aglo from being a joint venture along with Agarwal Group was its majority over the board, Your Lordship. And with the loss of majority of the board with the independent directors, it does not have the right to not only appoint or remove the directors, not only have the right to appoint and remove independent directors, or to increase and decrease the number of directors here in Your Lordship. It does not also have the control to direct the relevant activities, Your Lordship. That's why we're contending that there was no control in itself, Your Lordship. Further than that,
I know I shouldn't be asking these questions in a rejoinder, but a lot is being said about the independent directors. Is Soundarya a public company?
Your Lordship, because Sundarya is a subsidiary of a public, which is why we have complied with the appointment here in Your Lordship, merely complying with what the law requires us to do.
No, so my question was, I was about to come to my question, which was that in a situation like this, where there are independent directors in a private company, whose interests do the independent directors are?
The interest of the subsidiary, interest of the public, Your Lordship.
But where is the public here?
Your Lordship, because it is a subsidiary of a public company, Your Lordship. Because it is subsidiary, we have appointed the independent directors, Your Lordship. Such a rise of the public will come in the interest of the public in agro, Your Lordship. Whereas when people invest in agro, Your Lordship, it is also important that they look at how our subsidiary is doing, Your Lordship, which is now that it's no longer a subsidiary. And that is where our contention lies. Your Lordship, further, it is important to also note that it was commercially negotiated and contractually agreed upon that between the parties that it would in fact be a joint venture, Your Lordship. And at that point in time, we do not have exclusive control, Your Lordship. Further, Your Lordship, after the 20. After the 29 January Board of Directors meeting, Your Lordship, we have disclosed such information to the stock exchange in the stipulated time that the SEBI requires us to do, Your Lordship. Further, we've also done our due diligence in order to ensure that such non-exclusion in the consolidated financial statement is true. I have also laid down to you why we do not have such control, Your Lordship. That is the basis of our finding, which means that we've approached legal as well as financial authorities to confirm this status, Your Lordship, which means that it is legal, that it is no longer a subsidiary, but in fact a joint venture, Your Lordship, which means that we have also disclosed under the LODR and made such and removed the assets and liabilities of the subsidiary herein, which means that it is only natural at that point, Your Lordship, for the investors to look at such financial statements and make their independent decisions as to whether they want to invest in the company or not, Your Lordship. And because we had excluded such loss-making entities, which was a coincidence here, Your Lordship, and also contended that we legally are allowed to do so. At that point in time, the investors had enough time to make such decisions whether they want to invest or not, Your Lordship, which is why it will not amount to any sort of inducement. If I may just seek 2 minutes to complete my submission, Your Lordship. Your Lordship, further, it's also important to note that in the disclosures that but also in paragraph 27 of the proposition, with the table that is there, Your Lordship, exceptional items are still mentioned, Your Lordship, and highlighted, in fact, which is to prove that we have made the relevant disclosures to the investors, and if the entire point of the Securities and Exchange Board of India is to ensure that such investors' rights are protected. It is our submission that we have made all such disclosures and all such compliances in law that was required of us, which means that only after this we have made such derecognition of assets and liabilities, Your Lordship. Consequent to this, all such information that was made was already in public domain. which means that when Samir Aman and Anjali Arora were making such trades, Your Lordship, all the information was already intimated to the stock exchanges, and it is also seen in the fact that only their trades after January 29th is mentioned, Your Lordship, which means it is rightful in the part of the directors to make such trades, Your Lordship, and SEBI cannot put any restriction on such normal trading activity of the board of directors. So also, the board of directors see that there is a boom in the market, see that there is a profit to be made. It is only natural that people perform in such a way that it is profitable to them, Your Lordship, and that is our contention, Your Lordship. Your Lordship, further, all the trades were made were already public knowledge, which means that the gains that were made by the two directors was in fact legal, and these were rightful gains, Your Lordship, and they cannot put any sort of disgorgement claims on such amounts, Your Lordship. This is our primary contention. In response to the casting vote, Your Lordship, it is our contention that the case of a casting vote will not arise where there is no majority, Your Lordship. If I may just submit this last contention of mine, which is, Your Lordship, Aglo herein has 3 votes, Your Lordship. Along with the independent directors, Agarwal Group has 4 votes, Your Lordship, which means that there is no equal proportion or equality of votes that will come into place where the chairman in this case will be allowed to decide in the board of directors, Your Lordship, which means to say that such rights of the chairman, Your Lordship, it is very unlikely that they would occur in this case, Your Lordship, which means the casting vote that is counted, one, it is secretarial practice and common practice, Your Lordship.
And Council, your time is over.
Your Lordship, it is just that control is static at the end of the day, Your Lordship, and such determination must be made in light of that. It was an thank you.
Thank you. Your Honor, the time reserved for this deliberations is 5 minutes. I think the council will take only 2 or 3 minutes to answer all the questions. Acts of association, paragraph number 65, say that the of memorandum of understanding clause 6, they have the right they are conclusively passing of the information in the present case, Your Honors, establishes
Giving out of information mean inducement?
Your Honors, giving out false information.
Position of law. Whenever there will be a chairman, he'll have a casting vote.
What are your answers?
Isn't that the position of law anyways under the Companies Act? That the chairman will have a casting vote.
Your Honor, the respondent did not contest that this power given to the chairman is wrong. The respondent is only contesting that this power shows that Agro has the right to direct the implement. It has power. So it's not in dispute.
So, you are closing for the day. Do you need to make any announcement or? Thank you, everybody. Thanks a lot. Thank you for your efforts.
Hi, I request the participants to immediately move to the orientation hall. We will be starting with the valedictory ceremony in like 15 minutes.